Let's talk about retirement income and security. Congress and states have enacted statutory law designed to provide employees with some measure of security. First one up, Social Security. Obviously, it's been in the news. It's always been in the news. Different administrations have different views regarding Social Security. The Social Security system began in 1935 during the Great Depression to provide a basic safety net. The Social Security system pays benefits to workers who are retired, disabled, or temporarily unemployed, and to the spouses and children of disabled or deceased workers. The Social Security program is financed through a tax on wages that is paid by employers, employees, and the self-employed. This contribution is required per the Federal Insurance Contributions Act, or FICA. The Federal Unemployment Tax Act is part of the Social Security system that provides support for the unemployed. It sets federal standards for benefits, but the act also allows for states to create a system setting their own standards. New York has one. A worker who is terminated or laid off from their employment is generally eligible, but the key components is the worker must be able to work, and while collecting benefits, must make a good faith effort to look for an employment. An employee who voluntarily quits or is fired for cause is generally ineligible for unemployment. Medicare is another social insurance program. It provides health care to older U.S. citizens 65 and up, and for some under 65 who have disabilities. The Social Security Administration office administers Medicare. Medicare covers medical costs and expenses. The employers and employees contribute to help pay for the cost of Medicare. Group health plans and the Affordable Care Act, or as it's commonly referred to, Obamacare. I'm going to talk generally. There are always changes and always amendments. The Health Insurance Portability and Accountability Act, or HIPAA. What do we know about HIPAA is that our medical information is private and cannot be disclosed without our consent, right? Also key under this act is that employers who choose to provide health insurance coverage to employees cannot exclude persons from coverage for pre-existing conditions. The Affordable Care Act requires employers with 50 or more full-time employees to offer health insurance benefits. Employers may be penalized for failing to provide coverage or offering a plan that costs the employee more than 9.5% of their income. Continuing discussing health insurance, we have COBRA, Consolidated Omnibus Budget Reconciliation Act. Under this act, former employees must be allowed to continue their health coverage for 18 months after leaving their job, but the employee must pay the cost themselves and sometimes an additional 2% for administrative expenses. COBRA applies to any company with 20 or more employees. Let's talk about immigration law, another hot button topic in the political arena, but this relates to employers hiring immigrants and the rules surrounding that component. So we know that employers face serious penalties if they hire undocumented workers. The laws that govern immigration and the hiring of non-citizens are found in the Immigration Reform and Control Act and the Immigration Act. Until 1986, there was no risk for employers who hired undocumented immigrants. In 1986, Congress passed the Immigration Reform and Control Act. It requires employers to verify the identity and eligibility of all individuals hired in the United States after November 6, 1986. This means that the verification is a completion of a form, the Employment Eligibility Verification Form, or I-9 is what it's called. The agency responsible for immigration worksite enforcement is the Immigration Customs and Enforcement, or ICE for short. If it is discovered that an employer knowingly employed undocumented immigrant workers, the employer faces legal trouble. But what if the employer didn't know that the employee's papers were bad? Employers are required to confirm work authorization, which means that every new employee at the time of hire must complete the Form I-90. The employer is not expected to be an expert on the documents that establish work authorization, but must make a good faith effort to ensure that their employees are legally permitted to work in the United States. Under the Immigration Act, businesses are allowed to hire foreign workers with special qualifications. Regardless, though, the U.S. still caps the number of visas it issues each year for legal immigrants. So an employer who wishes to recruit workers from other countries must satisfy the Department of Labor that there is a shortage of qualified U.S. workers capable of performing the required work, and show that bringing in foreign workers to the country will not adversely affect the labor market in the employer's particular area. So they have a bit of a burden that they have to establish in order to bring in foreign workers.